Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate. In today's class, I will discuss about section 41A of CRPC and I will emphasize on the practical application of that section in context with offences under section 67 of IT Act. First of all, we have to note down the fundamental question. Suppose there is a FIR under section 67 of IT Act along with offences under IPC or BNS. Due to insertion of that section, police is willing to arrest. What to do? Whether we should move for the anticipatory bail or should avail the other option available under law to avoid illegal arrest. For this, we have to understand the legal provision. The judgment of Honorable Allahabad High Court is also required to be considered because the said judgment inter alia directly deals with the said problem. Judgment name is Anurag Gupta versus State of UP. It is pronounced by Honorable Allahabad High Court. Judgment date is 9th of December 2020. Petition number is 24560/2020. In that case, a petition was submitted before Honorable Allahabad High Court by the concerned accused to seek protection from the illegal arrest. As we know that in CRPC, specifically in the state of UP, at that time anticipatory bail was barred, and that's why a bypass was adopted, which is that to file a writ petition to seek protection. So in that case, the concerned accused submitted that he deserves the benefit of section 41A of CRPC, which is sine qua non, to avoid the illegal arrest. Please be noted, every accused deserves the benefit of section 41 of CRPC wherein the charged offence is punishable with imprisonment up to 7 years. And the said view is also approved by Honorable Supreme Court in an important judgment named as Arnesh Kumar vs. State of Bihar. Citation is 2014, Volume 8 SCC, page number 273. In which it is observed that the aim of section 41A of CRPC is to avoid the unwarranted arrest. As we know that when CRPC was in motion from the inception, 41A of CRPC was not the part and parcel of it. Later on, it was added by the virtue of section 6 of Code of Criminal Procedure, Amendment Act 2008, which is commonly called Act number 5 of 2009. So basically, we could say that the basic intent of section 41A of CRPC is to avoid the unwarranted arrest. Even the Honorable Supreme Court, in its judgment, as mentioned above by me, specified that the police is not bound to do the arrest in the mechanical way. While doing the arrest, they have to specify the reason. And apart from that, if you will peruse section 35 subclause 1 subclause B of BNSS, you will get that the arrest could be made only when the accused has committed the cognizable offence in presence of police and his further detention is required to avoid the repetition of any crime. Apart from that, he is going to threat anyone who is acquainted with the facts of case or going to disappear the evidences. In that scenario, he could be arrested. And apart from that, there is a possibility that the accused will flee away from justice. In that scenario, the arrest could be done. But in the routine way, the arrest could not be done, and it is also specified that while doing the arrest, the concerned police is totally bound to record the reasons. If there is no reason, arrest proceeding will be illegal and unjustified. So we could say that if the concerned offence is punishable up to 7 years, in that scenario, accused deserve the benefit of section 41A of CRPC or section 35, subclause 3 of BNSS. So in that case, it is submitted that if the arrest is not required, in that scenario, the police officer is required to give notice, directing the accused to appear before him at the specified time and place. If such notice is issued, the concerned accused is bound to comply with direction to avoid the arrest. So basically we could say that 41A of CRPC is basically an actor for accused to parry the illegal arrest. In that case, the direction was given to the concerned police to comply with section 41A of CRPC and guidelines laid down by Honorable Supreme Court in judgment of Jinesh versus State of Bihar. Citation is 2014, volume 8, SCC, page number 273. So in nutshell, we could say that the said judgment inter alia conveys three important information. Number one, 41A of CRPC is imperative for those offences punishable with imprisonment up to 7 years. It is totally immaterial whether it is under IPC or BNS or NDPS or POCSO or a cybercrime. Number two, regarding 41A of CRPC, we are having the important judgment of Honorable Supreme Court, that is Arnesh Kumar versus State of Bihar. Citation is 2014, volume 8, SCC, page number 273. And concerned police is totally bound to comply with the guidelines laid down by Honorable Supreme Court in that judgment. In case of non-compliance, we are having the right to initiate for departmental action against the concerned culprit officials. And apart from that, the police has to specify the reason why the arrest is sine qua non. If they are not having any logic or reason, in that scenario, the proceeding of arrest would be illegal. So I think that in today's class, I am totally able to enlighten all of you about the importance of section 41A of CRPC, specifically when you are charged under section 67 of the IT Act. So simply, we could say that even though we are charged under IT Act, and if the offence is punishable up to 7 years, in that scenario, we deserve the benefit of section 41 of CRPC. If the said benefit is not given, in that scenario, we may move for anticipatory bail or we may directly move to the Honorable High Court with submission regarding the illegal proceedings alleged to be conducted by the concerned police, so that we could secure our rights and could vindicate our grievances. See you in the next topic. Till then, Jai Hind, Jai Bharat.